SJC-11997, Commonwealth v. Jamie Resende.
Mr. Shapiro, good morning, and when you're ready, we're ready for you.
Mr. Chief Justice, and may it please the court. My name is Jonathan Shapiro, and I represent the defendant appellant Jamie Resende. This case presents the unique circumstance that Mr. Resende is presently serving lengthy prison sentences as a result of convictions at his first trial, despite the fact that he was acquitted of these very same crimes at his second trial.
But tell me, at the second trial, was there the... I appreciate the fact that the attempted armed robbery and armed robbery, perhaps, were the predicate felonies argued, correct?
Armed home invasion and attempted armed robbery.
The armed home invasion wasn't presented to the jury. I mean, wasn't given to the jury.
No, but the judge...
But just let me finish my question. There was no... What the jury had was a verdict slip asking, you know, how do you find the defendant guilty or not guilty of felony murder? There was no verdict slip for the predicate felonies that were being used for that felony murder.
Oh, yes, there was.
At the second trial?
The verdict slip had guilty or not guilty of felony murder, and then under that, boxes for the predicate felonies. Now, the predicate felonies that actually went to the jury were attempted armed robbery or unarmed robbery.
Right.
And then there was also a verdict slip for second-degree felony murder, in which case...
Did the jury cross off not guilty on all of that?
Well, they crossed off not guilty of felony murder. They didn't need to get to the predicate felonies.
But didn't Judge Healy, excuse me, not allow the home invasion to go because of the merger issue and that there wasn't a separate assault other than the home invasion, and therefore the jury never adjudicated the issue on the home invasion?
That's correct. The judge, in effect, granted a required finding of not guilty with respect to the armed home invasion predicate.
Why do you say that? Wasn't he just saying that there was no separate assault because of merger and Bell?
Well, that was the basis for his decision, but the decision was, in effect, a required finding of not guilty because the Commonwealth had failed to prove one of the essential elements of that particular predicate felony.
Well,
So,
is that really right, though? Because if in one trial the jury were to find, the reason it gets dismissed is because it merges with the felony murder, right?
that was the basis of Judge Healy's required finding of not guilty with respect to
Doesn't
that.
necessarily mean that the person is not guilty of the underlying felony.
That's
does it?
true, and that was, of course, the basis of the decision to grant a new trial with respect to the only predicate felony of which the defendant was convicted at the first trial.
But wasn't that because the instruction was not proper?
That's because the instruction...
It didn't have anything to do with sufficiency, it had to do with the instruction.
No, the instruction failed to
Right.
Apprise the jury of the requirement that there be a separate and distinct finding of an assault
Right.
in order for that to convict on that count.
Right, and that was the basis for the new trial, the instruction.
That's correct.
Yeah, and at the second trial, Judge Healy also would refuse to let it go to the jury on a theory of premeditated murder.
That's correct. That's correct. But the point is that it did go to the jury on the question of attempted armed robbery or unarmed robbery, and there's no merger issue there. So there's no way to logically understand the jury verdict except for a determination that the defendant had not participated either as an accomplice or as a principal in the felony, which underlied the felony murder conviction. So there was no basis for saying that that verdict somehow could be understood as not determining that Mr. Resende was not guilty of having committed the underlying felony of attempted armed robbery, as it could in the first trial, where the issue for which he was granted a new trial was the merger issue.
If there's,
I'm sorry.
Does that say anything more than that the verdicts were inconsistent? And generally, I mean, if it had been the same jury, if in the first trial the jury had said guilty of felony murder, not guilty of home invasion, and used home invasion as the predicate for it, would we say that they're inconsistent and cannot stand, or would we say they're inconsistent and we allow that to be because juries do things?
Well, this court has certainly said that there can be inconsistent verdicts. That generally, if not entirely, arises in a situation where you have the same jury making that decision. The point in this case is when the Commonwealth decided to charge Mr. Resende with felony murder and to retry him for felony murder at the second trial, it effectively reopened those cases for which he had been convicted at the first trial. That is, ordinarily, when somebody is convicted of armed home invasion, the armed assault with intent to rob, and felony murder, jeopardy terminates, and he can't be re-prosecuted. And so, if nothing else had happened after the first trial, of course, double jeopardy would prevent any further trials of Mr. Resende with respect to those offenses. However, by choosing to appeal and seek a new trial, he, in effect, waived the finality of those convictions. He waived the finality of his felony murder conviction, and he waived the finality of those lesser-included predicate felonies, in this case, attempted armed robbery and armed home invasion. And so the cases hold that when that happens, the Commonwealth can continue to retry him because jeopardy continues.
Can I ask you a question about that? Are you basically saying that the Commonwealth could have tried him again on the attempted armed robbery and home invasion as separate indictments? Because that's what happened in the first case. In the first case, it was felony murder as well as convictions for the underlying felonies. But that didn't happen in the second trial. The second trial only went on felony murder. No prosecution for the underlying crime. So that didn't happen.
They weren't separately indicted at the second trial, but each of those offenses was a predicate felony for the felony murder charge, and as such, they were lesser included offenses. So when he was placed in jeopardy at the second trial, he was placed in jeopardy for felony murder and those lesser included predicates.
My question was, could the prosecution have charged and gone forward with the separate felonies, like the armed home robbery and, the attempted armed robbery and the home invasion? Could they have gone forward separately on those?
I think they could have re-indicted him. In fact, I think that that would have made more sense, because then at the second trial, there's no question that the not guilty would have been applicable to those indictments as well. And given the only logical way to understand the jury verdict, it's clear that the jury would have acquitted him on the underlying felonies just as they did on the felony murder.
But if, to take Chief Justice Gantz's hypothetical in a different way, if you had a situation where someone was found not guilty on the murder, and there's only one predicate felony, which is armed robbery, and as you said, there's no merger issue with robbery, that's completely inconsistent, and the court doesn't speculate as to the reason. So why is that situation different than yours?
I don't think I'm following that.
Well, if you had a verdict that came back not guilty on murder, and it's a felony murder, and the only predicate felony is armed robbery, it comes back guilty on the armed robbery, and that's the only predicate felony, there's no merger issue with armed robbery, those verdicts cannot be reconciled,
No,
and we don't inquire as to the reason.
well, I think if that were the case, the court would have to deal with that, because a not guilty of the predicate felony, when there is no merger issue, is so completely and logically inconsistent
No, he
with
was
a
saying
guilty.
Weren't you saying a guilty on the robbery?
Flipping it.
Guilty on the robbery, not guilty on the felony murder. The only predicate is the armed robbery. There's no merger issue, and yet we don't look into the underlying reasons for the inconsistency.
Well, I think in that case you would have to,
Is there any
because
case that stands for that proposition?
because it's so completely inconsistent. A not guilty of the underlying felony indicates that the elements of the offense have not been proved. A guilty verdict on felony murder makes absolutely no sense under those circumstances. I've never seen a case where that happens, and I think that principles of double jeopardy, as well as principles of fundamental fairness, would abhor a result where a jury acquits of the predicate felony and nevertheless returns a verdict of
Good
guilty.
question. There are generally two grounds, either legal inconsistency or factual inconsistency. Your claim is really as to factual inconsistency, isn't it?
Yes, and the same situation where collateral estoppel would be applicable.
Do you have a case where it's as between factual inconsistency has been recognized as a basis for setting it aside, where it's two separate juries as opposed to the same jury?
I don't. And I think in many respects, this case is a case of first impression. I haven't been able to find any case where a similar situation has occurred.
In
I think
Massachusetts, right? I mean, have you looked outside?
I haven't found a case anywhere.
There's a case that we came across, State versus Johnson in Maryland from 2002, which indicates that most jurisdictions hold that the rule of consistency does not apply to verdicts from separate trials.
Excuse me?
Does not apply to instances of inconsistency between
Well,
different
I'm not
trials.
familiar with that case.
Okay.
But I think what's important here is to recognize that the Commonwealth made a decision after the convictions in the first trial and after a retrial was granted. They didn't have to retry Mr. Resende for felony murder. They could have required him to serve out his 18 to 20-year sentence for armed assault with intent to rob, and they could have sought to reimpose the armed home invasion verdict from the first trial, which would have required a sentence of no less than 20 years.
Now, when he was resentenced, doesn't it run concurrently with the first? I mean, he's not serving a longer term now.
No, well, he's serving a longer term because the second, he's sentenced to a minimum of 20 years on the armed home invasion, whereas the first was 18 to 20.
Okay.
So it results in being somewhat longer. But nevertheless, the Commonwealth made the decision to retry him for felony murder in order to get a life without parole sentence. They made that decision. In doing that, they in effect put him in jeopardy on those
Do you say
prior
that they were?
convictions.
So are you saying that they should have, are you saying that they were required basically to dismiss those indictments and re-indict for what they wanted to use as the underlying felonies?
I'm not saying that they had to do that. I'm saying that by putting him in jeopardy on felony murder based on these two predicates, attempted armed robbery and armed home invasion, they in effect waived the finality of those prior convictions and placed him in continuing jeopardy. Now, when at the end of the second trial he is acquitted, the effect of that is that his jeopardy terminates with respect to felony murder as well as to those predicates. The
Even
Commonwealth
though-
can't have it both ways. They can't choose to seek the enhanced life without parole penalty on those underlying predicate felonies, and then when defendant is acquitted, say, well, that's okay, we can still fall back and require him to serve these sentences on the prior offenses.
But would logic say that, let's just say in the first trial, the jury had found, I think this is sort of Judge Lowe's question, the jury had found him not guilty of the felony murder, but guilty of armed home invasion and assault with intent to rob, as they did. Would you say, given the not guilty on the felony murder, that logic would say we would have to reverse the two convictions on the armed home invasion and assault with intent to rob?
Yes, yes. Simply because although you could justify the verdict with respect to armed home invasion on a merger theory, you can't in any way justify the verdict with respect to the attempted armed robbery because there's no merger issue there. And if the defendant is found not guilty of a predicate felony,
No, no,
where
not
there's no,
guilty of the murder, not, he is found guilty of
No.
the armed,
well, if he's found guilty of the predicate felony and not guilty of the murder, again, there's no way to reconcile those verdicts, and you can't, and you wouldn't be able to justify them as the trial judge did by saying, it could be jury nullification, it could be sympathy, it could be prejudice. That didn't come into play here.
All right, thank you. Good morning, Ms. Lee.
Good morning. May it please the court, Mary Lee, Assistant District Attorney for the Commonwealth. Before I begin my comments today, I have to make an apology to the court for an error in my brief. I very much thank my brother for pointing it out in his reply brief. At page 10 of my brief, in the factual circumstances, I refer to the co-defendant, Scott, as the defendant, and that is an error. It is Scott's track phone that is found at the victim's home.
got it right later.
In my argument, it's correct, but it's all the physical evidence that is left at the scene is related to Scott, and also in the footnote on that same page, I refer to Tiffany Hill as the defendant's girlfriend. That is Scott's girlfriend. In fact, Tiffany Hill does not know
So
Jamie Resende at
The
all.
bottom line is Mr. Shapiro, I believe, is correct that there's no forensic evidence tying this defendant to the crime.
Yes, no physical evidence. So I'm very appreciative of my brother for bringing that to the court's attention, and also I apologize. I'll be more careful in the future. Now, getting to the issues in the case, My brother suggests that there is no case on point for the hypothetical that this court has suggested, which is that a defendant is acquitted of felony murder but convicted of the underlying felony. The Commonwealth cites the case on point in my brief. It's Commonwealth versus Blackwell. And it says that there is no error when a jury acquits on a felony murder but convicts on the underlying felony. And if you're looking for the policy reason why that's appropriate, you can find that analysis in the Medeiros case, which talks about inconsistent verdicts, that it's inappropriate for courts to look into the deliberations of juries and to try to figure out how the jury got where they are going on a case, because they can use all the evidence in the case, and they can decide what they like and they don't like. They can reach compromise verdicts.
That all may be true, but I guess there is a certain logic, not about that so much, but the cake and having your cake and eating it too. How can you not think that this is having your cake and eating it too? Well, you've got these convictions. It gets reversed by the trial judge because of what he perceived to be an error in his instructions. It's retried. You put the same felonies out there again, and he's found not. There's something that's sort of disturbing about putting the defendant in jeopardy on the murder again, but you've got in your back pocket these convictions back there. You're using again, and if he were convicted, I don't know what would you do if he was convicted? You would vacate them, right?
I don't agree with the statement, we're having our cake and eating it too. The Commonwealth did not want a retrial on the felony murder. We opposed it, and we lost that motion. We did not appeal it. We went forward on the motion for new trial. A man is dead, and the Commonwealth has the district attorney's office has a responsibility to put forward that evidence at the new trial. The convictions from the first trial were proved beyond a reasonable doubt at the first trial, and the defendant was entitled to a new trial on the merger issue for the armed home invasion, and so his new trial was for the felony murder charge only. And what the defendant is suggesting, if the defendant is right in this case, I say this most respectfully, that means this court is wrong in Commonwealth versus Bell, because in note 22, you affirmed the convictions for the underlying felonies, and you remanded the case for the retrial on felony murder alone so that the merger issue could be hashed out. And then when we got to the retrial, we attempted to put forward the armed home invasion, and Judge Healy found, and that's at transcript 211, 2015, at pages 179 to 180, he found that we had put forth insufficient evidence of separate assaults for the merger issue. Now, of course, after the second trial, this court, on this very same facts in Commonwealth versus Scott, the co-defendant case, said that that evidence was in fact sufficient. And now the Commonwealth has no appeal from that, so we were unjustly harmed in our retrial. We couldn't go forward on our best felony murder, and we had to rely on the attempted armed robbery. So we were very hampered at a retrial that we objected to and did not want, but we understand Bell came out after the first trial in this case, said the instructions are wrong, so we went back and did our constitutional duty and put forward the best case that we could at a retrial, which is always difficult. You have the same witnesses coming up and trying to rehash their testimony. They're subject to impeachment on their prior testimony now. It is very difficult to do a retrial on a case, and I think the defendant throughout his brief keeps saying, oh, it's the same trial except for the co-defendant's statement to the police. It was the exact same trial. I would suggest that you look at the testimony of Tiffany Hill in the two cases, and what you will see in the testimony of Tiffany Hill in those two cases is that very different, because she didn't testify that it was Kenston Scott on the phone in the middle of the night calling her at the second trial. She did at the first trial. Why is that significant? Our immunized witness, who had a lot of baggage, Vernon Newbury, testified that the co-defendant, Kenston Scott, used the defendant, Jamie Resende's phone after the shooting, and he thought he was calling a cab or something. Now, that was significant because Kenston Scott had left both his phones at the scene. That's why he doesn't have a phone. But it's also significant because he's using the phone. The phone records show 5 phone calls from Jamie Resende to Kenston Scott's girlfriend. Kenston Scott, that's Tiffany Hill. She doesn't know Jamie Resende. At the first trial, she says, sure, it's Kenston Scott on the phone. That doesn't come in at the second trial. His joint venture hearsay statements about having to leave the car behind, he'd done something awful, don't come in. And her admission that she reported that car stolen as part of this cover-up, she didn't say it was part of the cover-up, she reported it stolen to the police and to the rental car company. That didn't come in at the second trial. So all of that corroboration of Vernon Newbury, all of that joint venture hearsay, all of that tying it together didn't come forward at the second trial. As I noted, it's very difficult to retry a case. This is not us having our cake and eating it too.
And I take it that Mr. Scott was not retried at the same time as you had been at the first trial.
Mr. Scott went forward with his appeal. The defendant withdrew his appeal from the...
But they were separate trials.
They were separate trials. So Mr. Scott's appeal was pending, and then the decision from this court and Scott came out after the retrial in this case that would have shown that the evidence of merger was sufficient, that it doesn't merge, that there were sufficiently separate assaults. But Judge Haley didn't have the benefit of that at the retrial. So we went into the second trial handicapped on those issues. It was not us having our cake and eating it too. It is extremely significant under the doctrine of continuing jeopardy that the defendant has requested this new trial to correct these errors. That's why we get to go forward.
Is there any argument that the attempted armed robbery and the home invasion are different, since the home invasion never went to the second jury? There was never an adjudication, there was never an analysis of the sufficiency of the evidence. But the attempted armed robbery did, and Mr. Shapiro's point is that by definition, the Commonwealth didn't prove that predicate felony beyond a reasonable doubt.
So in terms of if you credit the argument from the defendant, they are very different because armed home invasion was never even considered by the second jury. So how can there be any double jeopardy violation? That claim is frivolous on its face because there was no second consideration of armed home invasion. As to the armed assault with intent to rob, which is his conviction that was essentially final at the time of the new trial because he had withdrawn his motion for new trial denial appeal. I'm sorry, I've said that so poorly. He withdrew his appeal on the denial of the motion for new trial with regard to the armed assault with intent to rob. And we had a finding from the single justice that there was no appeal pending in that matter prior to the trial going forward. We were under the impression that armed assault with intent to rob was a final conviction. We were not permitted by Judge Healy to offer that conviction. We had to then reprove it. Nothing in double jeopardy law, nothing in law of trials and proof beyond a reasonable doubt requires the Commonwealth to prove those convictions twice. And I would suggest that the armed assault with intent to rob is not something that should be then vacated just because there's a not guilty at the second trial. And I would point to the Coleman case. I know Justice Lank pointed out a case from another jurisdiction. The Coleman case is an appeals court case, and it was affirmed by this court. It's cited in my brief, and in that case, it says it is perfectly appropriate to have inconsistent verdicts at separate trials. And so I would suggest the Coleman case is a very good reason why this court should affirm the assault with intent to rob, even though the underlying felony of attempted armed robbery was presented to the jury at the second trial. And as for the reinstatement of the armed home invasion, I would point to the Therian case, the Wood case, Rollins and Evans that are cited in my brief, because once you have an acquittal on that felony murder, then the underlying felony comes back into play. So, and that conviction should be affirmed on those grounds.
Putting aside cake for now, Mr. Shapiro, though, I mean, has a point, and that question is what is its legal significance, that it appears recognizing that different juries can come to different verdicts and that the evidence at different trials always play out a little bit differently, sometimes better for the Commonwealth, sometimes worse. But this jury appears to have come to the view that the evidence was not, did not support a finding of proof beyond a reasonable doubt that he was a joint venturer here, when the earlier jury appeared to find that he was. Is that, do we simply say different juries can come to different conclusions? That's life. He was lucky, fortunate here to be spared the felony murder conviction, and that is fair? Or is there something problematic with the fact that he will be going to trial for 20 years after a second jury found that he was not, ultimately not guilty as a joint venturer?
Most respectfully, I would point to this court's decision in Medeiros, which I quote in my brief, and that goes to the point of not looking into the jury deliberations. This is a home invasion, and like many home invasions this court has seen before, you have a person who's essentially, the evidence showed, is running some sort of drug distribution unit. He pulled out his gun and started firing. We know he got at least one shot off with his .357 as people were trying to come into his home. And I would suggest, in circumstances like this, a jury might come to a conclusion of acquittal on reasons that don't have to do with identity as a joint venture or sufficiency of the evidence. I realize that Vernon Newbery had a lot of baggage, and that maybe that was his reason. Or if you look to a legal reason, the jury might have found that the victim's pulling out a gun and shooting his .357 and getting out his pit bull somehow cut off the causation that the murder occurred during the completion of the felony. So I think the motion for a new trial judge was right, that there are many reasons why. Yeah, one could be they don't believe Vernon Newbery, and we need Vernon Newbery's testimony because he's the one who said Jamie Resende called him up and said, I got a stick, it's out of house in Brockton, there's money and drugs, can you get someone to help? And if you don't have that, then it's a much more difficult case. But we don't know that the jury rejected that. The jury might have said, you know, that guy shouldn't have had drugs in his house. He got what he deserved, which is awful. And I hope that they didn't find that way, but people think that way sometimes. Or the jury might have said, you know, this wouldn't have gone the way it did, and he wouldn't have got killed if he hadn't pulled out the gun in the pit bull. And if that's the case, they might have found that, yeah, it was Jamie Resende who cooked up the whole thing, but it was the victim who caused his own death. And if those are the reasons, then the defendant loses. And so that's why this court said in Medeiros, we don't look at how we get there. We don't presume that the jury found insufficient evidence because the jury has all the power, and they're supposed to. So I would ask this court to respect the verdict of the first jury. I would ask this court to find no substantial risk of a miscarriage of justice. I would point out the defendant in the remaining three arguments uses the inappropriate standard of substantial likelihood of miscarriage of justice that's reserved for first-degree murder cases. I would ask you to use the appropriate standard under...
With respect to the arguments about the convictions that happened at the first trial, which was a first-degree murder trial, oh, you're just saying that substantial likelihood only goes to the murder, not to the underlying crimes?
Yes, yes. So substantial risk, and it's not the more favorable standard.
And before we leave that point, is it your view that we should not reach those issues because the appeal was waived? And if that's the case, don't we have to deal with ineffective assistance of counsel, or which would be a substantial risk standard anyway? Or do we just reach them and decide them?
I believe that the defendant withdrew the appeal from the denial of the motion for new trial. It's right on this court's docket. And I suggest to you that that is a waiver. I acknowledge, I believe it's Commonwealth versus Bly, where this court said even when things are waived, then you get a substantial risk analysis. But there's also substantive waiver. He knew he had a right to appeal. He had counsel.
Isn't that though, and didn't we say in Scott that it was an interlocutory appeal that was withdrawn, that would have been withdrawn in this case?
Right, in Scott, the defendant did not withdraw his appeal. The defendant in...
I know, but it was an interlocutory appeal.
Yes.
Aren't the three contentions that the claims that are made, aren't they direct, isn't that a direct appeal of the convictions?
I think that
Not just as to the motion for new trial?
Well, all the issues that he's raising, aside from the first issue,
That's what
were
I mean.
subject to the motion for new trial.
Right.
And he specifically withdrew his appeal from the
I
denial
know,
of
but
the
that
motion for new
doesn't
trial.
take away from the fact that they would be still basis for a direct appeal for his convictions, right?
So I would suggest that the withdrawal distinguishes this case from Scott, but if this court does entertain it, then the withdrawal, at the very least, should act as substantial risk, and none of the issues were properly preserved anyway, as I stated in my brief. So substantial risk is the correct level of review, even if you don't consider his withdrawal of the appeal at all.
Can I ask you one hypothetical question? Let's assume for the minute that at the second trial, the defendant had been convicted of the felony murder. Would the Commonwealth have then moved to vacate the armed assault to rob, with intent to rob, out of the first trial?
So I think yes. If this court sees attempted armed robbery and armed assault with intent to murder as being duplicative,
Intent to
then
rob,
that-
to rob.
yes, assault with intent, sorry. Assault with intent to rob, if you see those two things as duplicative, as the defendant argues, then the armed assault with intent to rob would act as the underlying felony. But I think in that circumstance, because the armed home invasion hadn't gone to the second jury, we could ask to reinstate the armed home invasion and get a sentence on that as well, which is what happened at the first trial. We had armed home invasion was the underlying felony, armed assault with intent to rob was the freestanding felony, and he got sentenced on murder and armed assault with intent to rob. So in the hypothetical you suggest, it would flip it around. It would take a little bit of, it would take a couple of motions to do it, but that's how I think it would come out.
Okay, thank you.
I would ask this court to affirm the convictions, and I apologize for going over time. Thank you.